you hear so many stories about the people having to go into the home,
yes,
and the children having to sell the house in order to pay
yes,
for it.
yes.
I mean, is there any way I can protect my children from that happening?
Well, the good news is actually there is a way, there is a solution to that. Long-term care is a major issue for a lot of our clients now, and we do have a strategy that will help to protect the family home should you end up going into care later on in your life. You did explain to me that you have 2 children, isn't that right?
That's right, yes.
And the house at the moment is owned in your sole name, would that be correct?
That's right, yes.
Quite simply, with your situation, there is a way that we can today, if you like, separate the house into two separate entities by creating a tenancy in common and conveying half of the house into what's called a probate trust. And what that really does is it moves half of the house into trust today for the benefit of your 2 children. Providing you stay out of care then for at least 6 months, which is the government's time frame for deliberate deprivation, as it's called, then the strategy has a good chance of working.
Go ahead. I take it deliberate deprivation means whereby you deliberately pass the house on to somebody else so that you don't have to sell it. So say something happened to me tomorrow and I knew I was going to have to go into care.
Yes.
If I go into care within 6 months, they can still take the house off me.
Correct. You're absolutely right. I mean, basically, if we did this planning today, and within 6 months you ended up going into long-term care, quite simply the government would claw that asset back into your estate as notional capital, as if you'd never done the planning. So it would have been a waste of time, effort, and money. So what we have to do is get past that first time frame of 6 months. Once we're past that, we're in with a good chance of the planning being effective. The next time frame that is important is the 18 months, because that's the current case law that exists, and that's actually Yule versus South Lanarkshire. A lady a number of years ago who was elderly, diagnosed with Alzheimer's, and knew she was going to be going into care. Her family were fairly well distributed throughout the world, so she knew nobody's going to be able to look after her. She was going to have to go into care. And at that stage then she basically signed away all her assets to her children. 18 months later, when she was entered care, the authorities obviously looked at her situation, looked at her medical records, and were able to establish that at the time when she gifted everything away, she knew that she wasn't going to get any better and was going to end up in long-term care with the nature of the illness that she had. So they were able to go to court and to prove that, and basically all those assets were then brought back into her name as notional capital. Now that's the current case law, and there's nothing to say that another case they might be able to go back 24 months or 36 months. So we can only work with the legislation that's available today.
Okay.
But what we normally say to clients is if we can get past the 2-year marker, there's a very good chance that the planning will stand up. The other time frame that's important in this is the 5 years, which is the insolvency legislation. And effectively nobody can come after you and put a charge on an asset more than 5 years after the date that you have effectively done the planning. Okay. So those are the 3 time frames that we work with, and clearly the earlier people like yourself do this sort of planning, the better.